So here's the thing, someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. Court is going to call 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
The attorney record, Monica Guerrero. I'm covering for Ms. Guerrero, Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's right.
All right, I'm going to need you to speak up, okay?
Yes.
All right, are you Brianna Mitchell?
Yes, ma'am.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge, violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive, intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. We'll waive the other violations.
Any objections to the state's waivers?
None.
All right. Did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge, will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the I may have put the case in TIC instead of the NPR. That's my mistake.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
None from the defense. And if I may put something else on the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Bexar County time.
So you're asking for credit from April 18th, 2016 to April 13th, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18th, 2016 to April 13th, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I have to.
Right.
I can
So-
check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18th to 2020, I'm sorry, February 18th, 2022 to April 13th, 2022, this was pending, correct?
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date. Can you look for that too?
So that was
So when this case was on the system, what date was that again?
January. And then she was running patient 12-10.
All right. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay, so we can go back on the record, Brenna. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692652, 692653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18th, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly weapon.
original?
Yes. Let me see something, just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. I'm assuming a weapon was involved, be it a vehicle or something else. All right, yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun, her client didn't have a gun. But that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, Do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right, good luck to you.
Thank you, Judge.
2022 CR 8246, State of Texas versus Tusca, Hamrik. Can I have parties announced for the record for the state?
Take a look into the state on it.
Defense?
Brian Kimbrough from Mr. Tusca Hamrik.
Probation, this is an application.
Oh, Judge, I'm sorry to interrupt, but it's Jason Garahan for the state.
All right, thank you. All right, are you Mr. Hamrik?
Yes, ma'am.
Counsel, have you received all the discovery?
I have your.
State will find that this, court will find that the state is in compliance with discovery. Mr. Hamrik, did you review the application for deferred adjudication and community supervision
Yes, Your Honor.
with your attorney? Did you sign it?
Yes, Your Honor.
Did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are. We're proceeding on each count, Your Honor,
All right.
which they're all the same.
So it's 1, 2, and 3?
And four.
And
There should
four.
be another page, Judge. I don't-
All right. Mr. Hamrick, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault with a peace officer or judge in counts 1, 2, 3, and 4? Those are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 20 years in each count and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hamrick, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine. State is recommending deferred adjudication in each count and an anger management course. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainants. Did you understand?
Yes, Your Honor.
Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1, how do you plead?
No contest.
Count 2,
No contest.
count 3,
No contest.
count 4.
No contest.
State any evidence,
Yes, Your Honor. Each of the counts, state exhibit number 1 with attachments.
any objection?
No objection.
And state, are the complainants aware?
Yes,
All right, thank you. You may continue to confer.
thank you.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilty as you've applied for deferred adjudication. Are you asking to proceed with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, I'd ask the court to file a plea bargain. Hamrik is 24 years old. He has no criminal record. He's a resident of Oklahoma. He lives with his parents in McCurtain County,
How do you spell that?
McCurtain County. And I would ask that his supervision be transferred to McCurtain County. I've spoken to his family. This is not characteristic of Hamrik. He's employed, works with his family, never been in trouble. And I believe he can successfully complete probation.
All right. So who is Marco Antonio Gonzalez to you?
I don't personally know him. It was,
Were you intoxicated? Because I don't understand. According to this, you were asking him to get out of the vehicle.
I was intoxicated at the time. Yes, ma'am.
Okay.
Yes, ma'am.
All right. The court will sentence you to $1,000 fine that will be probated. 10 years deferred adjudication. Counts 1, 2, 3, and 4 are to run concurrent. There should be a transfer to McCurtain County in Oklahoma. You're not transferred until they accept the transfer. Regular reporting by Zoom or in person. Regular random UAs. Probation, will they accept a transfer while he's in custody or no? All right, there should be no contact with M. Butler, C. Heron, Herron, S. Gatan, Sgatten, S. Shurtleff, that's Shurtleff, Laura Hernandez, Arizona Garza, Marco Antonio Gonzalez, and 4620 Thousand Oaks. And that's San Antonio, Texas, 78233. TAP evaluation in custody, probation. If it's discovered that they won't accept him till he's released, then he can be released. Follow TAP recs. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Field visits, 1 time per month for 3 months. And an anger management course. Probation, is there anything else he needs? All right, is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. You're gonna have to make better decisions. Otherwise, you're gonna find yourself in and out of custody. It appears that you have a drug or alcohol problem. If there are issues, just let probation know. If you feel like they're not addressing it, you can always come back to court, okay?
Sure.
All right, thank you.
This matter centered around Brianna Renee Mitchell, who was previously under supervision due to a homicide judgment prior to acknowledging various breaches, such as holding an illegal chemical, providing incorrect details, and escaping police. The trial proceeded simply, except there arrived an instant within court where all individuals stopped to analyze ancient files and detention timelines, demonstrating how files might occasionally remain as unyielding as individuals inside court. Judge Boyd closely studied the arrangement, validated the breaches, and canceled Mitchell's probation. She handed down a 10-year jail term while providing relevant lockup and national jail reduction. Prior to concluding the trial, Judge Boyd additionally gave useful guidance regarding childcare and going back with modesty following discharge.